Presenting KMJ.
Afternoon to you too.
Good afternoon, my colleague. My name is Machere Njero. I represent Law Society of Kenya, of which you are a member.
Thank you.
Good afternoon, Wakili. My name is Felix Koske. I represent the public.
Thank you.
Good afternoon, Council.
Good afternoon to you.
Mohamed Warsame. I represent the distinguished judges of the Court of Appeal in this commission.
It's a real pleasure.
Good afternoon, Learned Counsel.
Good afternoon.
Keharaka Yuki, the Attorney General, and I'm here by virtue of that office.
Pleasure.
Thank you very much, Council. We will not be with you long because already you engaged with us a lot.
Thank you.
And we still have those notes with us. But however, the commissioners would want to clarify one or two things or just fill up some gaps. And I'll start, Council, by asking you, just again in 1 or 2 minutes, expound on your experiences in two fronts. One, working as a member of a group. And I know last time you gave us some examples, but just emphasize that since this is a court where you work with others. And on the second front, your experience in writing, especially, I know you have not had a chance to write judgments, so how do you plan to learn this and to get the skill of doing this and be on board as soon as possible?
Yes, most obliged, Chairperson. How I'm planning to work with the others is I believe in teamwork. Teamwork is something more or less born with it. As I said last time, I come from a huge family. And then my experience from all the other places I've worked in, mostly it is teamwork, 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 nothing else. When we look at even these issues of taking matters to court, before even we take a case to court, we sit down as a team in the office and discuss and agree on the way forward. Yes, about writing. I'd submitted some few submissions some times back when I came in for the interview for the CJ. And it involves, apart from just going to court, usually before judgment is given, counsels are also advocates, are also expected to do their submissions. Apart from that, an advocate is a writer always. I remember, Chair, last time you had to correct me to tell me maybe I was writing too much. It's just a matter of writing and the skills of doing so.
Okay, my last question to you, Council, is that you're going to find a team of judges who have been there for some time, who are very good at what they do. They have perfected the art of writing those judgments and working together. So how do you plan to start knowing them? Because to work in a group, you must know them individually, collectively, to create the teamwork you're talking about. So how do you do that? Will you wait for it just flow, or are you going to have some, or rather to put some effort in knowing them, and how do you plan to do that?
Yes, thank you very much, Chair. When I look at the Supreme Court, what comes to my mind is, yes, we've had Supreme Court judges who've been there for a long, long time. I'm a very interactive person. It may not be a problem to me. I'm also very consultative. I will not just sit to do things without consulting with the rest. The other issue also is the qualities of leadership that I have. Once you're a leader, you don't go there showing off or fighting with your colleagues and all that. It is a matter of sitting down with them and learn from them until you get to where you'd want to be with them.
So there's no specific effort you make to get to know them. I'm just looking at some of the skills you may have, interpersonal, or will you just go and hopefully in the course of time you know each other? Or are there some deliberate kinds of some effort that you can make to actually know your colleagues better?
Yes, once I'm there, apart from getting to know them in terms of interaction, I would also work hard to ensure that in case a matter has come before the Supreme Court, I would be able to interrogate the same and be there with them. So that I just don't wait for them maybe to do everything, then I follow up to ask them, how did you arrive at this or this decision? I should be able to go out on my way and do also my research, do my work, so that when we meet together in maybe a conference or deciding on how to go about it, I would have made my input in that.
Okay.
Yes.
Okay, that is all from me. I will now request our acting CJ to please ask me some questions.
Thank you very much, Professor. Learned Counsel, one advocate is called advocate and two of them are called advocates. And advocates are also called, or another name for an advocate is counsel. So if one advocate is advocate, the plural of which is advocates, what is the plural for counsel?
I've never really thought about that. It's something that is new to me. I don't know whether to say counselors or counsels. Really, I cannot really commit myself to that.
All right.
Yes.
Learned Counsel, have you ever appeared before the Supreme Court?
No, I've not appeared
you
before the
haven't.
Supreme Court.
Please tell us what prepares you for being a judge on that court. And tell us the kind of advocate who should appear before that court.
Yes, what prepares me, first of all, are the qualifications that I have. I think I made the qualifications before you.
Let's leave the qualifications aside. Let me rephrase the question, Counsel. What practical experience do you have to enable you become a judge in the Supreme Court of Kenya, the highest court in the land?
Yes, if I may repeat what I said last time, is that I've had wealth of experience in the law courts. I've practiced all over the Republic, right from Kisumu to Mombasa, and have represented clients in various matters, so that when it comes to the issue of working in the Supreme Court, it may not be a very serious issue to me because I've interacted with the judges, I've interacted with the magistrates, I've read widely, and I've been able to do various matters concerning the clients. That is what I get from the clients.
Counsel, you must have heard this debate because it's been with us for a while.
Yes.
The advocate who is fit to appear before the Supreme Court, the age of that advocate, not by birth but by admission. You've had that discussion?
Yes.
Where do you stand on that discussion?
By virtue of joining the Supreme Court, that is, my lady?
No,
Yes.
I mean, for practicing advocates,
Yes.
there's been debate that, unless you practice for so many years, you should not represent a client before the court. You've heard the debate?
Yes, I've heard the debate.
So what is your view? Which age of admission of an advocate should qualify one to appear before the Supreme Court?
For me, as long as they've met the constitutional parameters.
So one could be admitted in the morning and in the afternoon appear before the Supreme Court. Is that what counsel is telling us?
No, we used to have, I don't know now, but we used to have a break period, that is after admission, for almost 1 year before you go and appear before the Supreme Court.
1 year old admitted advocate would be
before you start your own practice, that is?
I'm talking about practice before the Supreme Court. And it flows from the question we asked earlier about your preparedness. You've never even appeared before the court. It's not a disqualification at all, it is not. We just want your reasoning as to why, although you've never practiced before the court, you are nevertheless the right judge to join the court as judge number 7.
Yes, as I'd said earlier, my wider practice also come into consideration when it comes to that. But I tend to think if somebody has the qualifications to represent a client before the Supreme Court, I don't see why that advocate should not be able to be in the Supreme Court. And I tend to think today, if a matter is brought to me that touches on an issue that goes to Supreme Court, I'll not hesitate to go to Supreme Court and practice.
Have you interacted with the strategic plan of the court?
Yes, I've had an occasion to look at it, but not, I think I just glossed over it. I didn't do detail work on it, that is reading it in details.
What you read, did it involve the part about the court's desire to enhance access to and expeditious delivery of justice?
Yes.
All right. If it did, please give us the I don't want to call them key resort areas, although that's what they are called. Just give us the things that we have identified as the things that would lead us to not just letting litigants access justice, but access it expeditiously.
I remember looking at, I think, four or five pillars that should be enhanced to help in easy and affordable access to justice. I remember one of them was how to treat backlog of cases.
We are now talking about the key resort areas,
Yes.
not the pillars.
Maybe you can kindly
All right,
reframe the question again, madam.
Okay, let's
Yes.
go to something else. Which is your favorite case in the court? And then give us the reasons why you consider that case your favorite.
I've had an occasion to look at some.
Mm.
I may not want to really say that it is favorite, but the one that keeps on coming to my mind once in a while is the Muruatetu case.
Okay, beyond Muruatetu, we have discussed Muruatetu at least for 2 weeks. Beyond Muruatetu, what other case determined by the court are you familiar with?
Yes, I think the Mitubel case.
Okay, please discuss Mitubel and the issues in Mitubel and how they were determined.
I think the issue generally was eviction of people who had settled in some land. And on eviction, the question that was being looked at is the issue of whether was it right, considering that we have to protect the social rights of these people, including housing.
The Supreme Court that you want to join has both original and appellate jurisdiction. Please tell us how you approach the court on the appellate jurisdiction.
Yes, on appellate jurisdiction is when there could be an issue to do with interpretation and application of the Constitution. And also
Counsel,
when...
let me just redirect you so we get to the issue. It is how you get there to discuss what you have just said. How do you get to the Supreme Court on appellate process?
On appeal to the Supreme Court, could be two ways, from the Court of Appeal and also from the tribunals.
How? The route, the process of getting to file the appeal?
The matter must be, there should be a certificate issued by this, either way, either the appellate court certifying the matter to be taken to the Supreme Court, or in its own motion, or the motion of a direct litigant, then the Supreme Court can also certify the matter as going to Supreme Court to be determined.
Very good. Now, in certification, what is the criteria to be considered?
In certification, they must consider whether it raises constitutional issues to be of such a great public importance to be able to go to the Supreme Court. Alternatively, apart from that, then is it to do with the interpretation of the Constitution and the application of the Constitution?
Give us, of course, I need not mention that there is a lot more for consideration, but give us what the name of the main case where we began with the certification, where that criteria was set.
What comes to my mind is a new to case. Also, I have them, but the names don't.
Oh, okay, it's
just
all right.
come
But
immediately.
Newto did not deal with the criteria one has to meet to be allowed to file. Now, certification is in respect of a particular aspect of the jurisdiction of the court. And it is in that case I was looking for, it's called Stein or Haminas. You get the rest of the name. The criteria is set there for you to access the court, and it is to discuss something we call GPI. What would GPI stand for?
I've got no idea about GPA.
Matters of general public importance?
I think the shortcut that, sorry, the initials
I
that
gave
were
you the
used.
answer from the judgment. Finally, that court has several aspects of jurisdiction, some of which has not been invoked yet. Which ones are those?
Where the Constitution is not as clear as to what that court should do or not do. Where there is a gray area.
Such as? There's something called a state of emergency. The only court that can hear an aspect of the state of emergency situation is your dream court. And with that, my sister, I wish you well.
Thank you.
Thank you very much, Honorable Judge Amwino. Judge Wasame, is your turn, please.
Thank you, Prof. Wakili,
Yes.
what is your strength that you will take to the Supreme Court?
Last time I said that I'm a worker, very good listener, and a very good team worker, extremely good at it.
One weakness the Supreme Court judges need to know about you?
The weakness that I have is I trust quite a lot. And it reaches a point at times, maybe you lose it by over-trusting.
Okay.
But once I meet you, I treat you the way you are and I trust you. So that could be my main weakness. But usually it escalates and I find out that you're not trustworthy, then I keep quiet about it.
Okay. What do you say to be your philosophy in terms of?
Yeah, I'm very progressive and dynamic. And when I look at what is coming up, and that last time I explained to you, to this commission, what I'd been doing, this is a very dynamic society. And my philosophy is, as we move on, applying laws, interpreting laws, then also we have to look wholesomely as how the society is progressing, so that we keep on being also dynamic. And that is my philosophy.
Thank you very much, Wakili. I wish you well.
Thank you very much.
Thank you.
Thank you, Honorable Judge Wasame. Honorable Judge Majaja, it's your turn.
Thank you, Chair. Council. I just want us to go on from where we left last time. I asked you about the Maputo Protocol. Do you know what it is right now?
Thank you very much, Judge.
Yes.
You actually challenged me.
Yes.
And I thought, because of having been in the women's movement for so long, I don't know how I would have missed that. I went back
Yes.
and looked at it, and I'm so grateful.
Yes, so yes. What is it? Maybe now you can tell us.
In short, it's about women's rights, reproductive rights, issues of abortion, and all that. And when I see Kenya has not actually ratified it, reasons I don't know. It's a very good document.
You're saying Kenya has not ratified?
That's how I saw from the map of Africa. What they have is, yes,
actually, let me just put the record. Kenya has ratified it.
Yes.
But has made certain reservations.
Oh, thank you.
It has made certain reservations. So do you know the reservations?
I didn't go to that extent.
Okay. Let me put it another way. What are reservations to a treaty? When a country ratifies a treaty but puts reservations, what are reservations?
Maybe there could be some clauses they're not happy with, and they put in their submissions for purposes of having those clauses either expand, then that is the time those reservations are put down.
Okay. The other issue I asked you last time when we were here was knowledge management. Did you go and find out what knowledge management is in the strategic plan?
Knowledge management, was it in terms of training and...
You said you haven't read the Supreme Court strategic plan.
I just perused it.
You just perused it. Okay, I will leave it at that. You know that the Supreme Court is a pillar for devolution, isn't it?
Yes.
It is. If the Supreme Court is not there, chances are that devolution will fail.
It's true.
Yeah. And one of the mechanisms the Supreme Court supports devolution is by issuing advisory opinions.
Yes.
Yeah. We have had several advisory opinions. The Supreme Court has issued several advisory opinions. Can you tell me 3 principles about advisory opinions that have emerged generally? Just 3.
I think one is to do with the non-interference with the other state bodies or arms of the government, so that if they have their own mechanisms of dealing with an issue that has arisen, then they can apply the mechanisms that they have at that particular time.
Okay, another one. And is there an example of that kind of a situation where the court, which you'll be sitting, said that issue is being dealt with by in another way, we will leave the case? Do you have any in mind?
Yes, what comes to my mind is There was the issue of Senate and National Assembly having a problem on which parliament was in charge of revenue allocation. And I think they were advised to form a mediation or a negotiation team so that they can be able to sort out their issue, and not the court determining for them who should be in charge of revenue allocation.
So, have you read the decision on the advisory opinion on that revenue allocation?
Yes, but not in the deep sense of it. Yes.
Okay. So what is the other principle? What is the other principle? So we've identified one, another one?
The other one that comes to my mind is when it comes to the impeachment of governors. I think also there was the issue that courts should not really interfere.
Was that an advisory opinion or an appeal from the Court of Appeal?
Should have been an appeal.
It's an appeal, okay. So let's put that one aside. So there was another I was looking for. Okay, just give me another principle.
When I look
or let me put it this way. What has the Supreme Court talked about the binding nature of an advisory opinion? What has it said?
Yes, it's not that it came out clearly that once an advisory opinion has been given, then it is upon the bodies that the opinion have been given to look at it and work within the parameters of that advisory opinion.
Okay. And then another case. Have you heard of this case called Gitirao Peter Munya versus Dixon Mwenda Kidinji? Either called Munya's case. Have you heard of it?
I've glossed over it also.
Glossed
I think
over
it is in the strategic plan.
Yes, so when you glossed over it, what did that, what was the importance of that decision?
I think it was to do with the jurisdiction and whether the Supreme Court could open itself to allowing all the appeals go to it. Yes.
So what did it say?
I think the Supreme Court, in its own wisdom, realized that not each and every matter that emanates from the lower court, going to the High Court, going to the Court of Appeal, must end up in the Supreme Court.
Okay. And you talked about the Mitubel case. You had read that one.
Most of them have gone through.
You just glossed through. What right were the claimants in Mitubel asserting? What right? What specific right?
That is to do with the human rights, right to social justice, right to housing.
You said, there are specific rights. You know the case of Anarita Karimi Njeru?
Anarita Karimi
Njeru. Have you heard of it?
Yes.
Yes. Which says that a party who comes must identify the right they are asserting, because the Bill of Rights has specific provisions.
Yes.
So what was the specific right the claimants in Mitubel were asserting?
If it's a right to housing.
Yes, the right to housing.
Yes.
Now, just tell us briefly what the right, in your understanding, what the right to housing entails.
Right to housing is a right to having not only a dwelling place, but also reasonable place to live in, so that it is incumbent also upon the government and also for the courts to ensure that that right is stamped. It should be there for the people to enjoy.
So is it a right that entitles you to a house, for example?
All social aspects of it. Let's say a whole family living in that house, also to food and shelter. That is.
Okay, if you look at Article 43, it talks about right of access to housing. That's the phraseology used. So what does access, in your view, just explain to us, what is the state's responsibility in respect of fulfilling that right?
Yes, the state has a serious responsibility to do that, and I think one of the key issues that was put forward for purposes of ensuring development of Kenya is to ensure access to housing. So when I look at that, does it only mean to giving a person a place to live in, or to a house to live in? I tend to think even if today you come and put up your tent here and you live here, I think the state should ensure. I'm not saying that it comes to court and lives in the Supreme Court, but the court should also ensure that that right of enjoyment of that place you're living in is safeguarded.
So in respect of the Mitubel case, what did the court say about ensuring that right of access to housing?
I've not interacted deeply with the case,
Okay.
but I've lost
And
memory.
finally, Mitubel made a very important decision in respect of structural relief. Structural relief. Heard of that term, structural relief? Or structural interdict or structural injunction? Structural relief?
Honestly, I've not interacted with the case.
Okay.
Very well.
And that brings the end to my questioning. Thank you very much for your time.
Thank you.
Thank you very much, Judge Majaja. Commissioner Jero, please go ahead.
Okay, just a few questions. I'm just wondering, we have so many advocates and there are so many judicial officers, judges, who ultimately dream of getting to the Supreme Court. I mean, it's the most coveted prize, so to speak. The ultimate dream of any legal practitioner. Which means that you want the very best to go there, considering the position, in the apex court.
Maybe, can you kindly clarify? I did not get you very well.
I'm saying
Yes.
that the Supreme Court, every advocate, every judicial officer, every judge, that's the ultimate prize, Supreme being the apex court. So the question I'm asking myself, for you now as a candidate, you would have to show us that you are prepared for it. You are prepared for that position in the Supreme Court, the coveted prize. So what is it that you have that you think has prepared you for it?
Yes, as I explained earlier, one thing, I have the qualifications. Secondly, I'm a hard worker, and I'm ready and willing to work in a collegial way. And to add on to that, and I said it last time, though it brought some bit of laughter, that I'm a go-getter. If I go there, we sit together and we work, we'll be able to move places.
Yeah.
As they're doing right now, but adding on to that.
Yeah. But you see, the problem is that everybody will say the same thing, so it means that you have to have that proven qualities, where you're able to say, yes, this is what has prepared me. And why I'm saying that, we have very experienced judicial officers who have been here who are asking for the same position. And you see, they're able to show from their legal philosophy, which you can discern from their decisions, from their writings, you can see, yes, we could give this person a chance. So that's why I'm saying that in terms of that track record, besides saying that you're a hard worker and you're a college, you're a teamwork and all that, what material, what is it that you can be able to give us where we can justifiably say, yes, you can also consider Alice Yano for this position? That's what I'm looking for, and I'm still not getting it.
I don't know how to put it, because when I said initially that I have the qualifications, I've already interacted with the courts and I've really worked hard. I've represented clients. And so that when I come here to ask for this kind of a job, I'm not coming in as a stranger. I'm coming in to build on what is there. And I've said again that coming together and feeling that you're able to give to this the court your own expertise from elsewhere else, then we'll make it a better place. And I repeated last time, and sorry, I said last time, and I want to repeat it again, that I think we are aware that most of the cases in this country, in fact more than 80%, I'm not sure, are outside there, where some of us have really practiced it. And we understand really what is there. So that when we come here, we have that experience we are bringing with us. Because it does not mean I should have worked in the High Court or Supreme Court or Court of Appeal, or even appeared in the Supreme Court to represent a client. That makes me be able to work in the Supreme Court. I have a wealth of experience.
I hear you. The minimum qualifications you have, it is that extra. So that you see, perhaps, if we're dealing with application for, a High Court judge, probably the standards would be different and would entitle you to what you are saying that you're able to bring. But you see, the standards will not be the same if you're dealing with a Court of Appeal judge. It will certainly not be the same when you're dealing with a Supreme Court judge. So I'm still, probably maybe I'm not very sharp, I may not be getting it, but you see, I'm the one to mark at the end of the day, so I still need to be convinced. And why I'm saying that, judge number 7, which is now my last question, this person, the moment they get there, they have to be ready to roll. They are the people, this is the person who starts now, generating drafts probably, The others have already learned, so you've had, probably if you listen to the previous interviews, this person is being called a mono, in the strict sense of the word, because you start doing so much. Now, there's no room for learning curve. There's no room for learning curve. You've got to be prepared for it, and you've got to have that track record that is able to show you are prepared for it. So where is it, if I may still ask?
Actually, that is a real advantage to me, because if you go there immediately and you're given that kind of work, and that I want also to repeat the fact that I'd already said that I'm a hard worker. Within a very short time, I would have learned the ropes. So instead of just going to sit to be collegiate, and I'm given this work, Yano, go and do this research, bring us this, so that when we sit together, we can look at it, all of us. Then that is the best learning. Within a week, I'm there. Yes.
Okay. All right. That's all. Thank you. I wish you well.
Thank you very much, Honorable Commissioner General. The Honorable Attorney General, is your turn, please.
Thank you very much, Madam Chair. Good afternoon, Learned Counsel.
Good afternoon to you.
Let's just follow that last point that Commissioner Masheri Anjiro raised. You have become a member of the court.
Yes.
You have just finished hearing the first petition.
Yes.
And you conference with the 6 other members of the court.
Yes.
And then you're told, please go and write the judgment.
Yes.
What would you do?
Yes. First of all, I'll look at the facts, or the way the case has been presented. Look at the law. After looking at the law, also generally, look at the law generally. And then do research and merge all. then I bring it to the other team, we look at it.
How would you go about constructing that document called a judgment?
Once I've done the citation, then I bring down all the facts from the parties. Then after bringing down all the facts from the parties, plus whatever submissions they have attached to them, then thereafter I research and look at what law goes in to support this, which part of the Constitution goes in to support this. Then from there now, I do a conclusion. From doing the conclusion, then I can bring the matter before the other team.
Thank you, madam. What does the word collegiality mean to you in the context of the Supreme Court?
What comes to my mind is the teamwork that is supposed to come together. Actually, it's more or less a court where the team come together, majority decision is taken. If not, then each and every party, or the party who is not collegiate or who is not ready to take the side of what the majority have taken, can also be able to write their own differing decisions.
Madam, I think that's what you would do at a conference when you've heard a case and you discuss it to see which way each judge wants to go.
Mm-hmm.
But what is collegiality in terms of relationships, in terms of the workings of the court, in terms of your independence to make decisions as a judge?
Collegiality to me means that this is a college of judges, Supreme Court judges. They are together to do the mandate of the work that they've been given, such that if it reaches a point where they have to write judgments, and I'm thankful for that part of the conferencing. What they can do, they can just listen to the matter at hand. They can either do independent judgments, or they can agree that letters, if they've come to the conference and they've arrived at the same decision, majority has arrived at the same decision, they can agree to have one of them do the judgment.
All right. Madam Learned Counsel, in the course of your preparation for this interview, did you come across any challenges that are currently facing the Supreme Court? And if so, could you name just 2 or 3?
Yes, from what I've heard, because Commission AG have not been there. From what I've heard is there are some few challenges, but I think these are challenges that can be surmounted, and especially when it comes to the number. And I've seen, I think from the strategic plan, there is a feeling that the number of the Supreme Court judges be increased from 7 to 9 because of the cases that keep on coming to the Supreme Court, increment in terms of cases coming to the Supreme Court. Then the other one I've been hearing also is the issue of backlog. And backlog in the sense that maybe could it be the numbers, or could it be also the other or the other various responsibilities that the Supreme Court judges engage in, to the point that they may not really have all their time absorbed in their core mandate in terms of the decision making.
Thank you. Finally, have you familiarized yourself, madam, with the Supreme Court rules of 2020? What
Yes.
I should like to know is whether the Court of Appeal, or rather the Supreme Court, can review its decisions, and if so, in what circumstances?
Yes, the Supreme Court being the highest court or the apex court, its decisions are binding on all other courts, but its decision or the decisions of the Supreme Court do not bind the Supreme Court. They can as well move from an original decision to another one, maybe even if the facts could be the same. The reason why is so much is happening, the world is dynamic, we never know the decision that was given maybe about 10 years ago, whether it's still going to bind after another 10 years. So they have that leeway of reviewing their decisions.
What principles would guide the court in reviewing its own decision?
I look at the changing society, which also brings amendment to laws and all that. So they will not be static. Something changes and they must change also.
Very well, madam. That will be all from me. Thank you very much for asking the questions. Over to you, Chair.
Thank you.
Thank you, Honorable E.G. Commissioner Ishohi, it's your turn, please.
Thank you, Chair. Council, good afternoon.
Good afternoon.
Good, I'll be very brief because we covered most of the issues last time we were here, but nevertheless, let's look at one or two things that we can be able to discuss. As a public officer and a state officer, the use of public resources is very, very important in terms of efficient and effective use of those resources. What legal framework will guide you as you use public resources as a state officer in case you get this job? Legal framework.
Yes. I think the most important thing, and that is what runs through, is the issue of accountability. One has to be extremely accountable in terms of making returns, and apart from also making returns, communicating.
Okay.
To
I want you to focus on legal framework. There must be a legal framework that you guide how you are going to use the public resources, and there are a number of them. Just give us two.
I look at the audit, also budget. So
Those are policies. I'm looking at the legal framework, legal instruments. Are you familiar with the Public Finance Management Act?
yes,
Another one? I've given you one at least.
public procurement. Yes.
Okay. Yes, you can look at that. Are you familiar with the Code of Conduct of Judicial Officers? Code of Conduct and Ethics for Judicial Officers. Are you familiar with that code?
Yes, I've had an occasion to look at
Okay.
it.
If you look at that code, number 46, talks about conflict of interest. Would you share with us how you'd be able to manage in case you get a situation where you have a conflict of interest as a state officer, as a judge? How would you resolve that? How would you address it in terms of the code that I've coded for you? Code of Conduct and Ethics for Judicial Officers, number 46.
Yes, if there is conflict of interest, it is upon the judicial officer or we are talking about Supreme Court judge now, to open up and show out this is where there is a conflict, so that then that officer will not be able to move on with what they're supposed to be doing, or he's supposed to be working on, or she's supposed to be working on, without that interest being known to the others.
Okay. In the case you have that conflict of interest, how are you supposed to register those interests? To whom are you supposed to register them?
That is, if it is a Supreme Court, sir?
As a state officer, as a judicial officer, yes.
Yes. If there is a issue of conflict of interest, I think the best you can do is raise it with the president of the court, or even raise it to the colleagues.
Okay, you can look at that code when you refer. Finally, Chair, Council, you will see that you had looked at the strategic plan for the Supreme Court from the year 2020 to 2024. If you look at that document, there are stakeholders' expectations. They did involve stakeholders. And there are two key stakeholders of interest to me and to the Commission. One of the key stakeholders there was this Commission. And we had three expectations for Supreme Court as a stakeholder. And I'll give you two of them. One was implementing JSC policies. Two, professionalism. If you get to the court, the Supreme Court judge, how will you meet those expectations of this commission as a key stakeholder in that court?
If I was in the Supreme Court to meet implementation of the strategic plan,
Yes.
I think that is something I delved into last time. What I will do is ensure, because strategic plan, when you look at the main thing that runs through is the issue of the backlog of cases.
No. Council, through the chair. I'm talking about stakeholders. They did identify this commission as a key stakeholder in the Supreme Court. And this commission had expectations, the same way they have expectations to this commission. The expectations of this commission in that plan: one, implementation of our policies. Two, professionalism. My question is, if you get this position, and I hope you get it, and you're in that court, how will you be able to assist in the realization of those expectations? How?
I want to look at it from the point that through working together as Supreme Court judges, we should be able to be collegiate and come up with strategies also that can help the Commission meet its own threshold.
Okay. My last question, Chair, to the Council. The other key stakeholder in that court is the accounting officer. In this case, the chief registrar. And that office has two expectations from that court. One is prudent use of resources, and two, timely reporting. What is the understanding of those two expectations and their realization?
I think from the way I look at it is, if they have, let's say if they have to prepare a budget, then they must be able also to consult with the registrar of the High Court for purposes of ensuring that what is expected for the Supreme Court is met.
Okay. Reporting, what is the understanding of the reporting?
To me, it tells me accountability.
Accountability. Thank you, Chair. Thank you, Council.
Thank you.
Thank you very much, Commissioner Gishohi. Now is the time for Commissioner Koskei to engage the Council.
Thank you, Chair. Good afternoon, Wakili.
Good afternoon, sir.
You are back again.
I'm back again.
Yeah. What is your motivation? What motivates you, or what really motivated you to apply for this position?
Commissioner, that's a very tough question, and you're not the first one to ask me. I saw the advertisement, and I looked at the what they had put down as qualifications, And in me, because I'm a go-getter, something just, I wake up and I say, yes, I can do it. This is something that I can do. It's a conviction in me. And I know when I say I want to do this, I'll do it. And I do it perfectly. So that's why when I applied for it, I knew this is not a main task, and I'm going to work harder to be.
Thank you. Now you have applied for this position in Supreme Court. Looking at Supreme Court the way it is now, the way it operates, its composition, what is this one thing that you look at perhaps as a gap that you are coming in to perhaps switch it to enhance its service delivery?
Apart from, of course, saying that I'm a hard worker, there's also something that I feel that maybe I can take to the Supreme Court. And I feel that we need to demystify the Supreme Court. Actually, even this notion of maybe the Supreme Court is not working, the perception that maybe there's a backlog and all that, it is that issue of not communicating. So I believe what I can bring in is to ensure we sit down and try to demystify. At times, even what comes to my mind is, though I don't know, sorry to say, maybe I don't know the law, what says about Supreme Courts where they are situated. Is it that it is cast on stone to sit in Nairobi, or can it be that maybe once in a while they move to Kisumu, another time they move to Mombasa or probably Nyeri, so that that issue of looking at the Supreme Court there and feeling that this is not a court of wananchi can get to enter into the people that is our court.
Okay, my last question is on Article 232, which it says, like during appointments, you have to look at or to ensure that there is fair competition, and also you look at merit. But it says that that is subject to two things, H and I, which says subject to representation of Kenya's diverse communities, and secondly, affording equal opportunities to men and women, members of all ethnic groups, and people with disability. The country has been, has been with this constitution for the last 10 years. And you hear every other time people talking about it. But it looks like little is being done about it. To the extent now that people believe whether you get it by merit, on merit, or your qualification makes you get a position, they still believe that tribalism has been practiced. There has been, discrimination. How, in your opinion, how can we ensure that this article is, implemented fully, not only in judiciary, but in the entire country, so that everybody will be satisfied for whenever there is any outcome of competition or any placement in public service?
Yes, I look at the Constitution, and the Constitution actually is a living thing. To me, it is living. It is only us. Maybe, okay, we put enough breath into it so that it can breathe. The way it is written, it is done in such a way that it should be able to, I don't know which word to use, but it should be able to bring this patriotism in Kenyans, that we feel we belong for one and to each other. We are together. So that when this constitution was promulgated, everybody in this country was happy, and we are happy about it, really. We're happy about the Constitution, because it is all representative, it is all, it's bringing people together, and that is what we need to have this Constitution. May I put it this way? What we need to do is to fairly translate this Constitution to meet those standards that the people created them for themselves. And especially Wanjiko, because this is not a constitution that some few people sat somewhere and crafted. This is a constitution that came from the people, and it should be able to represent the people equally, without bias, without any basis, take issues of gender, take issues of disability, take issues of diversity, ethnicity. All that should be brought together as the Constitution demands of us.
Thank you, Wakili. Thank you, Chair.
Thank you very much, Commissioner Koskei. Commissioner Rwade, please wrap up the session for us. Thank you.
Thank you very much, Chair. Good afternoon.
Good afternoon.
I just want to read for you a section from the Births and Deaths Registration Act and get your feelings or your views about it. Section 12. No person shall be entered in the register as the father of any child except either at the joint request of the father and mother or upon the production of the registrar of such evidence as he may require that the father and mother were married according to law or in accordance with some recognized custom. Essentially, that section is saying you can only be entered, a man can only be entered in the register as the father of a child he has sired if he has willingly, together with the mother, submitted an application for his registration, or if there is proof that he is married to the mother in accordance with the law or some other recognized custom. What is your view about that provision?
Yes, Commissioner, I think it was overturned. I can remember there was a case that overturned that it's no longer a serious requirement that you must get the consent of the parent to have that name entered into the birth certificate.
It was declared unconstitutional.
Yes.
What was the rationale?
It was, of course, discriminatory against the poor child. Well, I say somebody who did not have powers to say, yes, this is my father and I have to be registered. Because I remember there were a lot of cases, really, you go to court and even you feel bad. Because here is a child who's been dragged to court for the court to order that this child's name appears in the father's birth certificate. It was a very, very emotive issue.
Yes, and any other reason? Any other rationale behind declaring it unconstitutional? Did it violate any of the rights of that child other than discrimination?
I think also what came out, if I remember well, was a name, really. Why should you refuse anybody to have any name they want? Because I can decide today to add also another name, not necessarily my father's name, or not, like how I would want to put it. I want to put it this way, to say the name, yes, may confer that child a parentage, but then can't that child call himself or herself the name of this man without necessarily having to confer parental rights?
Without conferring parental rights? You got it right. You got
Yes.
it right. The issue about the child's right to a name and an identity.
Yes.
Is that bit that has taken...
No, the identity. That child must have an identity.
And the parental responsibility?
Yes, must have the parental responsibility.
Thank you.
Yes.
My second question, I want to give you a hypothetical situation God willing, you make it to the Supreme Court as a Supreme Court judge. And the women in Marakwet are so happy to have one of their own in the Apex Court. And they invite you, or they request you, to be a guest of honor in their fundraising. Their fundraising to raise money to operationalize a CBO, for example, to assist women get redress. Women who have suffered gender-based violence to get redress. What would you do?
Okay, first of all, I know that a state officer, they did away with state officers doing harambes. As for the other limb, I would maybe probably help them look for legal representation somewhere, but not really fundraising for them, because they can as well go to, if it is an issue maybe to go to court, they can go to some of these other bodies like FIDA and all that.
Thank you. Do you believe in mentorship? And if you do you do mentorship? Do you practice mentorship? And how do you go about it?
Yeah, thank you very much, Commissioner. Actually, from the days I was in high school all the way to the university, to the point that I am right now. As we are talking right now, Commissioner, I have 7 children I'm mentoring and taking care of, unrelated to me. Because you see the society the way it has come to be. And we have also issues to do with offices, workplaces, and all that. So at times we go out of our way to mentor, even our own. You'll find even you can have a worker who you realize could have gone into some problems. It's a matter of mentoring them and ensuring they go the right way. So those are the things that I've been doing. And also, we have a program, our church program, which we hold periodical meetings wherein we call the youth especially. We concentrate so much on the youth to mentor them and also give them life skills so that they can be able to get a way to earn a living. Yes.
Thank you. And finally, you've already told us that you're a hard worker.
Yes.
But I would want to hear from you. This is a bit difficult, I know. But I just want to hear from you. How do your colleagues describe you?
Maybe you should repeat that. Colleagues, yes?
Your colleagues at the bar. If someone were to ask them, please describe for me Wakili Alice Yano, how would they describe you?
Okay, for the ones we've worked with, we've had very cordial relationships, extremely cordial relationships. In fact, as we are talking right now, most of them maybe who could be even having some matters in Kajiado. Usually they call me to hold their brief, or in most cases, those ones who stay in Nairobi, or in most cases update me on what they would want me to go to do in court, and I even do hearings for them. So I have cordial, very cordial relationships with them, including even conveyancing. I do for them most of their conveyancing work.
Thank you very much. I wish you well. Thank you, Chair.
Thank you very much.
Thank you very much, Commissioner Roger. Thank you, Council. And that actually brings us to the end of this interview, Council. And we want to thank you for coming for the second time. And we want to thank you also as a commission for showing interest in serving the public. And we hope, regardless of the outcome, because we don't know how that will be, you'll keep the desire to work for the public even in future. So thank you so much. Do you have anything to tell us today?
Thank you very much, Chair. Last time I think you must have been a bit in a hurry because I remember that's the time they filed those cases. Because I was waiting for that chance,
Yes.
but then I realized the press
Yes.
was already surrounding you.
Yes.
Thank you for giving me this chance. Commissioners, I want to thank you very much for giving me this chance. I'm very happy, first of all, not only giving me this chance, but also showing confidence in me. And I know from your able way of doing things, you will come up with the best. I wish you the best. Thank you so much.
Thank you, Council. Once again, on behalf of my fellow commissioners, we wish you well. Thank you.
The globe as a whole. Both countries have not been exempted from the effects of the coronavirus.